neuromarketing. Would anyone like to discuss that?
Neuromarketing is happening, and actually there are a number of companies looking extremely intensively into how to do neuromarketing better. I think the debate is very much ahead of us because those who use it will argue that it's of course for our good. Because products and services will be even better suited to our needs. But then again, do we necessarily want the outside world, and especially the corporate world, to know the intimate details of our preferences, right? That's the choice that we will be facing. So I think it's a completely new chapter with regards to how to address this. And Arlene mentioned rightly the questions of identity, integrity, autonomy. And since I think a lot of us spent a good amount of time thinking about AI and the AI Act, and these are the same issues, right? The list actually overlaps, except that neurotech goes even deeper, right? Because it goes right into the brain, and it means it really goes much deeper in touching upon the questions of identity, especially. So we need to be aware of it. So far, neuromarketing at the moment, you know, it's a little bit like a Wild West, meaning it is developing, it is progressing. There are companies that think this is the great new promise. They will continue to argue it's really for fitting the consumer with an even better product and a better service, right? But it does come at a cost, so we need to be profoundly aware of the strings attached.
Can I make a quick comment on identity, because I think that that's a very relevant issue as well. And I think that it is important also to probably make a distinction between two kinds of identity, personal and human identity. And in the case of neurotechnology, it seems to threaten both. What do I mean by this? There is this sense that some people have, there is some literature on this. This is not prevalent, but it may happen that people sometimes feel after DBS that they are not themselves, right? So in that sense, some people have argued that there is a potential threat to personal autonomy when changes. But there is also what I mentioned before, which is human identity. This idea of what are humans? Am I a cyborg now? You know, I mean, what does it mean to be human in a context in which I am being assisted by a neurotechnology? So that's why I think it is interesting to really consider those two types of identity as being potentially threatened by some developments.
I'll also say something really quick about neuromarketing, Reagan. So I also have a background in neuroscience, and when I was getting my PhD, it was sort of the onset of fMRI. And I will just mention, sort of piggybacking on Pavel's comment before, of how neuroscience has laid so much groundwork for neurotechnology. I mean, there's a whole field called neuroeconomics where there's been a lot of imaging studies done with marketing messages and marketing in general. So this field is ripe for a technology to use that knowledge, years of work. So it's not starting from ground zero or scratch. And I think there is a trajectory we're seeing. So it definitely will happen.
Yeah, and if I can briefly abuse my position as moderator, I think that this really underlines the parallels that a lot of these new technologies have, and that we can't just focus on neurotech because we still have surveillance capitalism. So it's really important to address like the business model of tech and how it has been operating, because we will just see more harms and like displacing the problem into more intimate areas of our lives, of our brain, of our data. So. Definitely, thank you for raising that question, very important part. I will take a brief question, and then I would like to transition us to governance. Yes, please.
Well, my question is brief, it's relevant to governance. It was the answers that were long.
Okay.
So, and this is very much following on from both of the last two things that Arlene said. we're seeing a lot of this too. And one of the things I'm worrying about is the extent to which people are trying to bypass conscious, deliberate choice. So like in Twitter, that they're sorry, whatever you want to call Twitter right now, that they direct you towards for you, which often for me is actually my friends or something, but saying things that they know that I would get annoyed if I saw and be able to fight with them about. Whereas I have lists, there are things that I think is worth my 20 minutes a day, you know, and so this, a lot of the social media don't even have the option anymore for you to make deliberate choice. And so I think this is actually a huge, you know, it's a moral hazard, it undermines accountability. Facebook, from what I understand, they no longer want to know how their product works. So they're rewarding people who when they make interventions, later the sales go up, right? They're just looking at causal graphs to figure out who to give money to. But they do not want to know because then they could be asking Congress, right? And so I think we really, really need to look at both the corporate level and the individual level, reminding people that what explicit is and how that ties into moral agency and moral agency.
Absolutely.
So it is a question. I'm like, I was wondering if this is something you've been talking about in the neurotech, because I imagine it's even worse there.
I think again, if I
Go ahead.
can really fast, I think again, this is you're pointing to a vulnerability. How again, neurotech can make us vulnerable, and AI and innovations can make us vulnerable. And I think that this is certainly part of the reflection and the to-do, right? How to increase awareness. How to, and I think probably you have quite a bit to say about this, because it requires a number of steps, including not only informing, but also engaging with different audiences who might be very concerned about these things or might not understand them in the way that they could understand them. So yeah, there are a number of things that can be done, and there's a lot of reflection around that. So yeah, that is a concern that is very seriously taken into consideration.
Okay. Did you want to add to it? Okay. Please speak into the mic just to make sure people in the back can hear.
Perfect. I think this is working. So my background is in law and policy, most specifically on privacy. And so I can only wholeheartedly agree with the concern that you expressed that indeed we're giving away more of our agency when, in fact, the concept of agency as such when it comes to data processing operations is enshrined in law. The main basis for having any kind of data processing is consent. But it is true that nowadays, I think people most readily consent to something that if they knew the full extent of the processing that goes on behind closed doors and its consequences, they probably would think twice. But then again, there's an issue of transparency. I, in my previous organization, under a different hat, researched extensively with our colleagues the level of transparency that there were involved in many of the privacy policies in different social media platforms. And unfortunately, most of the time, we could only just scratch the surface, just see the tip of the iceberg of the level of processing that was taking place. But I'd like to tie that in with a question on neuromarketing, because it is true that, at least in principle, it sounds like a particularly intrusive way of displaying sponsored content. And as a result, it seems particularly harmful. But I think that considering the level of data processing that goes on nowadays, there's only a very small gap because we have no idea the level of inferences that can be drawn from the data that we willingly make available, what acts as proxy data for something else. And platforms may understand it, or they may not, because very often they're unwilling to dig further into their own systems. But we already don't know those connections that are being made. And maybe neural inferences are a far step from that, or maybe it's just a small step further.
Thank you, Laura. I think that brings us nicely into the governance question, because we are covered, most of this is covered in the GDPR, right? We have consent, we have data minimization, we have all of these user rights. Problem solved, right? We don't need newer technology laws. So I want to give a sense of all of the different approaches and governance discussions that are happening that relate to neurotech, maybe not all actually, but just some. And I want to start, let's start with the international and then we'll go to the EU. So Arlene, can you start us with some of the international, what's going on with neurotech?
I can mention briefly some initiatives from probably a part of the world that one doesn't think might be pioneering these type of initiatives. And for example, one typical example is Chile. Chile has amended its constitution. So now in the constitution, there is an article that specifically protects neural data. This is again quite a huge development because to a great extent, it is the result of the initiative, what is known as the Neuro Rights Initiative, that has been lobbying for the introduction of neuro rights in different constitutions. So Chile has been the first and only country so far that has amended its constitution to recognize this right, let's say. But there are other initiatives. In Argentina, there is a criminal bill law that specifically says that data from the brain can only be used with a court order and when the person has consented to it. Otherwise, again, the brain data has to be protected specifically. And there are a number of other attempts in Brazil, in Mexico, and of course in Europe we have Spain and France now is working towards that, and of course the governance experts here are going to talk more about this. But that is one part of the equation. There is also the possibility of self-regulation. And I wanted to very briefly mention that there are concerted efforts, for example, the IEEE, which is the Institute of Electrical and Electronic Engineers, the biggest professional organization there is, has been working actively working on trying to foster a much more responsible culture when it comes to the development of neurotech. And they have actually a very good, that easy to visit if you go to their website, neuroethics framework that actually describes the landscape and tries to give some guidance regarding what are the main points to consider when it comes to the ethical, legal, social, cultural issues raised by neurotech. But in addition to that, the IEEE is working on the formulation of standards, and those standards are supposed to provide much more specific guidance to developers so they can actually design responsible neurotech. So I just wanted to mention that it's not just about what we could call hard law, but there are also important self-regulation efforts in progress.
Thanks, and I think the establishment of neuro rights has been controversial and welcomed at the same time by different groups, and good to know about the guidelines for developers. Pavel, can you tell us a little bit more about some other governance initiatives?
So I'll zoom in on the European Union, which is well equipped to deal with problems in neurotechnology, but this approach is not at the moment domain specific. And what do I mean by that? Well, we have the General Data Protection Regulation, which applies to different types of data emerging from different technologies. We can ask ourselves, is it relevant for the neuro data? Well, it is, and brain data is covered. This would be considered as personal data given its biometric characteristics, but the GDPR was not drafted with developments in neurotechnology in mind, right? So also in the implementation, we can safely assume that there is not a sufficient body of expertise to guide the practical implementation decisions. So that's with regards to data. In the medical field, we also have the medical device regulation. Again, it's not in place with neurotechnology in mind. You can argue that that's the beauty of it because it's generic and it applies to any type of development that you can see. But the downside is that, again, it's not based on a sufficiently strong pool of expertise and knowledge about what are the implications in this very field. So neuro device would be considered high risk under medical device regulation. It would be treated accordingly, but we don't have anything brain specific in it, right? So a device that has to do with treating a knee and a device that has to do with treating the brain would fall under the same premise, right? There would be high risk designation for a brain-related device, but this is the only distinction. We don't have a body of expertise standing behind the implementation of the medical device regulation. So there is a certain question to be posed here. And then with regards to consumer devices, the EU is also well equipped to start with through the General Product Safety Regulation, which has been recently amended, and it's very state-of-the-art, you could argue. But again, it's not domain-specific. It doesn't look at the neuro devices which we have now in growing circulation. And of course, there is the AI Act that we have mentioned already. So I think the real debate, and we ask ourselves this question actually at a very interesting workshop we held yesterday, namely, should this be domain-specific, or can we rely on these more generic tools and then see how they adapt to the needs in neurotechnology? I think at the end it will be pretty much a political decision. Do we have a Neuro-technology Act, as it would be called in the European context, and everything neuro-related is put in that one basket? Or do we use what exists, and there is a lot, but if that is the case, we certainly have to do hard work in adapting the tools to the needs of this field.
And I wanted to also go to Laura, if you could tell us a bit more about how neurotechnology and the AI Act intersect, and possibly also the Brazilian AI Act, if that covers it better than the EU one.
Thank you very much. I'm going to be here building up on a lot of what Pavel has said, because as many of you working in EU policy might know or looking to get into it, the EU relies on a constellation of different laws, and each EU law just basically builds on the shoulders of giants that have been already there for a long time. So the AI Act does cover neurotechnology, or at least it appears to, even if it does not directly mention it. As you might already know, the AI Act covers anything, or considers AI anything that is a machine-based system that, based on some input, creates then some output. And obviously, lots of neurotechnology tools would fall within this category, so they would be within scope of the Act. Now, the Act does something very interesting, but also very typical of EU laws, in that it keeps going back to previous legal instruments, for example, the GDPR, for its base definitions. And it matters in the context of neurotechnology, especially when we're asking ourselves, how far can this technology go? What sort of data can neurotechnology generate? And I understand that there's a little bit of a debate in the field to what extent is neurotechnology personal data? Is it health data? Can it be considered biometric data within the meaning of the GDPR? And can we then apply that in light of the AI Act? So just to give you a very broad overview of what the AI Act does and how it could regulate technology, neurotechnology in particular, it essentially creates risk-based categories for different types of AI systems, ranging from unacceptable to what it considers to be minimal risk. Unacceptable risk AI systems are completely banned under the Act, but then there is another category which is recognized as high risk, which is still allowed subject to many safeguards and restrictions. And the AI Act defines high risk in a very broad and open way, in that it doesn't say restrictively these technologies are high risk, but rather takes a top-level view and says, depending on the area in which these are developed or deployed, they will be presumably considered high risk. And this includes law enforcement, border control, critical infrastructure, so the usual ones, but also biometrics. So do we consider that neurotechnology causes or creates data to become biometrics? The definition of biometric data goes all the way back to the GDPR. It doesn't specifically cover neural data, but there are some people who argue that neural data could be biometric data, and so it would fall within the biometrics category of high risk under the AI Act. What does that mean? If we agree that biometrics, neural data is biometrics, and then biometric data comes as high risk under the Act, then all the high risk obligations apply. And then again, there's that ongoing conversation about to what extent is that regime suitable for neurotechnologies. I also wanted to go to the question of medical devices regulation that was mentioned by Pavel. And this actually is something that was made known to me very recently in the context of a different workshop that many of us were present at yesterday. Increasingly, it seems the EU is trying to move from having two completely different pieces of legislation applicable to a product that does essentially the same thing, but for different purposes. Traditionally, medical devices regulations or directives were only intended to cover things that were manufactured for a strictly medical purpose. But obviously, there were many, many tools and products that were falling through the cracks, and so that wouldn't be regulated as thoroughly just because they weren't manufactured for a medical purpose. And many manufacturers would say, we're not doing anything medical, we're just making this available to the general public, and then people will use it as they see fit, but it's not a medical device, so we don't need this whole host of regulations to apply. Which, fair enough, but then that meant that there was a Wild West, as has already been mentioned, of products that just would completely escape regulation, even though what they were doing with data was just as risky as those medical devices, except the justification perhaps wasn't there. I mean, every time you have a product, there is a risk surface. If there is a medical need or a medical interest, then maybe the risk assessment scenario, the balance works out. But if it's just a product that's being made available for consumer use without there being a medical imperative or need, then obviously, why is that risk surface even being created, right? Why? And that is a personal question that people can individually answer. Do I really need this if there's no specific need for the product? Now, the current medical devices regulation goes a little bit beyond this. There's an annex in the medical devices regulation that covers products that were not manufactured for a medical purpose, but are still falling within the remit of the medical devices regulation. And I understand as of yesterday that contact lenses are on there, for example, just as a standalone category, and there are many others. So there is a discussion that in the future, maybe some neurotechnologies could be included with this annex so that they would be captured beyond their medical use and application. Now, that is not really a question for the lawyers. I think this question pertains to ethicists and philosophers more so than anything else. But just setting it out there to also let you in on some of the tensions that are present sometimes in regulation. Very often, we want to make sure that medical devices have the highest level of regulation of safeguards, which makes complete sense. But in so doing, we sometimes forget that some of these products are made available for consumer use without a medical need, and at the same time, we might be generating all this data that is just as vulnerable as the medical data. And just a quick note on the Brazilian AI Act. There is a host of new AI laws being proposed the world over. The Brazilian AI Act is one of them. It's still in proposal form, so it's still not become law. But I did want to mention it, and I know several other panels will cover it today, just because it is quite unwavering in its commitment to human rights and non-discrimination. And I think that's what truly makes the strength of a law, you know, how forthcoming you want to be with those protections. And as some of you might know, the AI Act perhaps hasn't gone as far. So just putting it all out there to also advertise all the sessions taking place later today.
Thank you so much, Laura. So we have quite a bit of ways in which neurotechnology is implicated and covered, but a lot of questions remain about the applicability, whether or not and to what extent brain data is extra sensitive, that it might require a little bit more specific protection. And as Laura was talking about, this blurring between medical and health data, I guess, like a Fitbit probably doesn't cover, you know, doesn't have such strict regulations, but it sure does collect lots of data. So I wanted to, so I think this touches on the question of like the gaps, like where and to what extent there are gaps. I also wanted to open up to the audience in case there are questions or comments that anyone has about the sort of governance or regulatory approach. Mariante. Can you project? Can you hear us? Okay.
I will try to speak a bit louder.
Thank you.
So my question is, I hear that, of course, I mean, some of you have mentioned that this might be a Wild West, where others are saying, well, we're not starting from a blank check. There's already some regulations that can apply to neurotech, and I understand that there's discussions. But I am interested to know if you can go a bit deeper, and from your perspective, if I was a policymaker, would you recommend that we go further than what is existing? Is there any additional layer of protection to address some of the harms that have been described in the beginning? Thank you.
Thank you. Great question. We also now have a mic, but we heard you. Who would like to take this question first?
I can offer a preliminary answer. I tend to be, funny enough, having a legal background, very reluctant to engage in new lawmaking processes simply because they're long and sometimes they have unexpected outcomes that diverge very, very far from what was originally proposed or even debated with civil society. I would say it's crucial to get a good understanding of the different intersecting pieces of legislation that cover neurotechnology. I think there's a lot of interest in having that clarified also for people in the field to know what exactly applies. And I know I can already hear the people from the private sector screaming, saying we need clarity to be able to complete or fulfill our compliance exercise. And by the way, the acronym that's beside my name, PE, is not private equity, it's just the country where I'm from, it's Peru, so just making that clear. So I would say we need to have that solid understanding of what comes together, and then after consultation with experts in the neurotechnology field and academics that have worked on this very long, just get a good understanding of what actually works in neurotechnology, because I feel that, at least in the negotiations of the AI Act, there was a bit of a misunderstanding sometimes between legal experts and technologists about what was feasible and what wasn't. And I think that conversation perhaps also needs to happen in the neurotechnology field so that we don't end up creating laws that completely miss the point, that fail to fundamentally understand the technology, and in the end, end up doing more harm than good, especially when we have good, solid frameworks with good protections.
Thank you. Pavel?
Yes, I agree with Laura that one should be very careful before jumping to the conclusion that we need something entirely new. Having said that, it is a fact of life that these laws were not designed to deal with neurotechnology devices, right? And the GDPR was drafted without having neurotechnology in mind, right? So when you read at the definition of biometric data from the perspective of sort of neurotechnology experts, well, you try to see what was not there in the intent of the lawmakers. You see what I mean? And I think we have to use all our imagination that is available in order to make sure that existing laws are applicable. So the biometric data definition would, for example, include behavioral characteristics. So that's where it goes into the territory of brain data. Now, some of us would argue that also pre-behavioral characteristics should be included. Now, is it a sufficiently potent argument to reopen something like the GDPR or put forward an altogether new Neuro-technology Act? Well, I think we have to think very carefully about this. Where I think more will be needed is on the implementation side of the equation, because there is clearly not sufficient knowledge and expertise in all the enforcement bodies and agencies to deal with neurotechnology devices. So guidelines for enforcement and implementation are definitely needed. I think we need to be very careful about jumping to the conclusion it's the new law that has to be drafted. We have to take stock of the existing body of legislation first, see where the gaps exist, because there will be gaps, right? But the question will be, are they big enough in order to have an altogether new effort?
Thank you, Pavel. I don't think you'll be the only person at this conference.
I just wanted to kind of second Laura's and Pavel's opinion. I make a quick comment. I think that I do not have a legal background, and yet, because of what I have read and being part of the discussion, I am really reluctant to think that we can just so simply say, okay, let's go for new rights or let's go for new instruments, legal instruments. However, though, as Pavel said, it is true that there are some differences, some aspects that need to be further addressed. I would say that before we jump to the conclusion that we need anything new and to avoid the risk of reinventing the wheel, we really need to be much more careful in trying to understand really, first of all, is the meaning and the meaning beyond the meaning, the value we give to certain things such as data, and particularly brain data, what it means, how we value it, why we need to protect it exactly, what is it that we need to protect of brain data, and so on. And this is just an example. There are a number of things and issues that neurotechnologies raise that I think need to be better understood in order to later on decide which instruments can be applied, which can be tweaked accordingly, and so on. So I wouldn't just jump to new things, but consider the situation really carefully, which is what many of us are trying to actually do. Slowly, but try to get to something that will be ultimately more productive, I think.
Thank you, Arlene. That's very well said. And I was going to say that I don't think you will be the only people at CPDP who are interested in more effective implementation and enforcement of the GDPR.
We are the first session, so
We are the first session. We might be the first to have said it. So yes, I think this, this careful approach resonates as well. So I also want to transition us to another part of the policymaking process, which is public engagement and consultation, the design process. This is often where, especially in the EU space, it's not done as thoroughly as or as long as we would like, and I think sometimes we see that in the outcome of certain laws, like the AI Act, for instance, that Laura mentioned. So I want to go to Daryl to talk a little bit about, as he is a public engagement expert working on this in the area of STEM. What steps can we take to ensure more responsible development and use of neurotechnology that involves public participation?
Sure. I think I'll just start with reflection for you all, maybe to wake you up a little bit and let you think about your own lives. So, I mean, as a society, would you agree that maybe we should have a do-over when it comes to smartphones? And social media and the apps associated with that. It's sort of an embarrassing public moment for me back in 2009 when I was attending Macworld, which was the conference in San Francisco for Mac developers and Apple enthusiasts. When one of the early iPhones came out, I was staring at it up in sort of this glass vitrine, looking at it sort of like a technological messiah, when a New York Times reporter turned to me and said, "What do you think?" And I said, "It's everything I ever wanted." So that was a very different world back when we may not had such a skeptical view of big tech. We've lived through a lot since then, some of us, and it makes me wonder, repeating a really good way to sum this up from a participant in this meeting yesterday, several of us have talked about, what's the world we want to create together? What do we want? And hopefully this time, having that precede technology and companies telling us what we want. I think it's even more critical now. I think there's questions of what do we mean by we? Who's included in that? And also thinking about putting values, our values, values of others, values of vulnerable populations first, before development. And that's a good way to sum up public engagement. Folks need to be asked, they need to be invited, they need to be engaged. There has to be a discussion, there has to be a conversation about this technology and this kind of development. And often it's something that's put last, something that I think Reagan implied. It's a checkbox, it's a website, it's a survey, it's a public hearing that happens at an obscure hour, at an obscure time, at an obscure location. Or it might be a process that isn't so inviting, that often captures sort of the same voices. I think we need to be more innovative. We need to think about partners. There are professionals in this space. There are people that do public engagement for a living. This is not something we need the public to come to us for. It is not something we need scientists and companies to often take on their own. It's something that we can find true practitioners to do with us. And I think it's critical. With all these discussions around neurotechnology, I've been thinking a lot about maybe we're already making decisions that are dangerous. I think some of you have seen, I can't remember the name off the top of my head, but there was a wonderful documentary about the deaf community and what it meant when cochlear implants became more popular and more accessible. I think there's fundamental questions about the diversity of our mental lives and what it will mean, and to borrow some phrases from my ethical colleagues, if we all regress to some normative level, which is entirely possible in this kind of technology development. I have a really close friend who's on the spectrum. What would it mean if those populations are suddenly told, well, wouldn't you rather be normal? Or if this was something that just happened without consent of young children at an early age to conform? And what if that technology was accessible to parents? I think these are the questions we have to ask. These are the questions we have to pose. These are the questions we have to work on together with diverse public audiences before this happens. I'm heartened to hear there's laws, there's policies, things are being developed. That also needs to be done in partnership with the public. But more importantly, I think these conversations have to happen because even with all of this in place, it's possible consent could overrule that, or these giant companies would just pay fees and sort of move on. I know these laws have good intentions, but they might not cover all situations. We have to help public audiences, diverse groups, be aware and participate in these conversations. And I know it's hard. I know it takes a lot of work and a lot of funding. But I think in this particular technology development, with it being so tied to our identity, we can't do anything less.
Thank you, Daryl. And just to play devil's advocate, as someone who has also asked the EU institutions on many occasions to involve more public participation, how would you do that? Especially if folks aren't experts, they may be directly impacted, but how do you get that time and those resources? And what is a truly effective way to hear those voices and implement those ideas into the policy design process?
It's not easy. And I think we often rely on old methods of, like I mentioned, hearings, maybe online surveys, websites. I hate to be a broken record, but I really feel like the solution is finding partners that do this. Think about the organizations in your community, in your cities, in your regions that interface directly with the public. These are educators, these are science museums, these are community groups. They are the experts and they need to be involved in this process. I've worked my whole career in science museums and children's museums and understand there is often a cultural barrier to have scientists working with educators. There's a lot of preconceived notions from scientists, from policymakers, that the public just doesn't understand enough to participate in this conversation. Often, their solution is just more education, more information. They have to be at a level that will allow them entry into these conversations. I think what I would remind folks is everyone has opinions and values that are valuable to offer in these conversations. We not only need to think of these people in the beginning when we're creating this technology, but they also have to be asked, especially youth, what is the potential use of this technology? Where could it go? These are ways, or they will come up with things that creators or developers never imagined. So I understand this is hard work, and I do feel like the truth is, the true pathway forward is making sure these partnerships are established with people interfacing with the public. It can't be left to the public to do, it can't be left to the developers to do, and policymakers. There has to be another component.
Absolutely.
Can I make a quick comment? I was thinking of your devil advocate a question. I think that sometimes, because it has happened to me as well, that people will say exactly the same thing. And so I think that many times that question is produced by two different attitudes. One is that some people do not really believe that they do not see the value proposition of engagement. So therefore they resort to, how do you do it? And then it's so difficult that. But then there is the other genuine question of how do we do it? And I think that it is important, for me at least, I have understood that in most cases it is just very difficult to really convince people that it is important to engage different publics in this. And I do think that, as I said in the workshop yesterday, it seems that it is challenging also because there are different ways to introduce the public, and sometimes introducing the views of the public is just what we could call engagement washing. It's just saying we engage, but really not meaning or not truly fully engaging with what they are saying and not truly listening to what they are saying. And I think that truly engaging means being open to changing the conversation. So including publics to address a number of issues entails not only inviting a number of people who usually are not invited to the table, but also being willing to change the discussion. Sometimes we invite people to talk about the issues we want to discuss. So to what extent is a truly inclusive engagement? And I have heard this again said a lot, particularly in people coming from other cultures. They will say, we are invited, but we still have to talk in terms that we do not agree with, and therefore we do not talk. So we are there, we listen, but we're not truly engaging, and we're not truly being included in the conversation. And for the longest time, I couldn't understand exactly what that meant, because, well, are you not sitting at the table? But I see that. I mean, if you're sitting at the table and people speak a language that you don't understand, or a language that you do understand, but you're not particularly keen to really engage with, well, then you feel that you're not part of the group. And I think it is important to engage and to include not only different people, but also include different perspectives and different topics and different framings. It may actually mean changing the frame in the discussion.
Thank you. Pavel, you want to add? And then we're coming to the close of this panel, so I will ask you if you have questions to think about them, and I'll
Want to take questions first? Yeah, I can go. Okay, I'll be brief, because what I wanted to say is that in order to achieve this in real life, you need to encode it in the different processes in tangible ways, right? So, what I would, for example, suggest with respect to research projects is to adopt the principle of an embedded patient researcher, which we don't have in Horizon Europe projects. Yes, there is a general expectation of patient inclusion, but this would be different. This would mean that the patients are actually in research teams, right? That there are budgets allocated to them in order to integrate their experience into a given research projects. There is a shift in medicine from disease focus to patient focus going on in many areas, and this is related to the fact that there are more disease-modifying approaches rather than curing approaches, and patient experience becomes all the more central and valuable. But in order to harness that experience, you need to have the patient actually at the table and in the team.
Absolutely, thank you. Incorporating impacted voices, thinking about processes, going to communities, thinking about framing. These are all really great interventions. I've seen the Institute of Neuroethics and the work that they've been doing for participation and engagement, and there's a lot to draw inspiration from, I think, for policymaking processes that I would love to see more of here. So we have two questions, one here, and I will please request to be brief. Yes, thank you. And we have a microphone, actually.
It's a microphone, great. Okay, thanks. Joanna Bryson, plus, I don't even remember my title. Anyway, it doesn't matter. I totally agree with that you want to have iterative development and have your users involved with your technology development. That's called agile development. It's been true. We've understood since 2000. It's really super important. And I agree in the AI Act we didn't do this. I want to be even more devilish in my devil's advocate, though, because what I saw was 5 years at least of constant opportunities for people to put in information, huge amounts, bigger responses than we've ever had at every stage, and then at the last minute, a pile-in. So I'm actually I really want to challenge what Laura said, because you did a beautiful description of the AI Act. You talked about the fact that all AI regulation, all general EU regulation has this wonderful foundation, and then you said there wasn't enough about fundamental rights in it. The fundamental rights were foundational, and we turned something that was a very clean way of bringing something really important, product law, to digital products. People were calling these things services and evading the law before. We turned something really clean into a giant bloatware that has all kinds of holes that GAFAM are going to exploit. So I don't see that in this case, where there had been this beautiful but complicated suite of law, that what happened in the last year was a good thing.
So the question is?
The question is again, the more devilly thing. Exactly as you said, you don't want to have laws sometimes. We had to build a new law. We were very participative. Suddenly people saw it was a big deal, and they piled in and they broke the law. Right? Mm-hmm.
So broken laws, what do we do about it? And then there was another question back here. Maybe we can take a couple, and then we'll give it was back there. Any other question? Okay. And the one more there.
Yes, thank you very much. My question, I have a background in philosophy, so my question will obviously be very broad and perhaps naive, but I was wondering, within the debate on the legislation of neurotechnologies, what are the main dangers which are addressed? Because you said that sometimes the debate does not really concretely address the real problems. Perhaps we have some kind of an imaginary which is linked to science fiction and stuff. So, yeah, very concretely, what are dangers which are present and which are serious and which are considered within the real debate which is going on?
Thank you. We'll take one more question.
Hi, I just saw the other day that one big tech company wanted to develop a new device with the brain waves, ATC, and also regarding the virtual reality glasses. I would like to ask if, in the case that there is a law, this law will be connected with every country. It will be like European law, or like if any country has a different way of approaching that, or how can we deal with that?
Okay, thank you. So we have 3 questions. One about broken laws, another one about the sorry? Participation breaking laws. Okay, yeah, Laura, why don't you go ahead?
I want to address the particularly devilish question. My take is I don't think it's civil society participation that broke the law. I don't think having more civil society participation is a bad thing. I think that what breaks the law is when inputs are gathered and decisions are made about what inputs are taken forward and others aren't, in secrecy or with a glaring lack of transparency. And this is to some extent what happened with the AI Act, because all these inputs were gathered, and then we go into trilogues and there's very little transparency or even access to what's happening in the room. And then we end with versions of the text that we hadn't even imagined. Things get thrown in there that weren't even contemplated in the initial proposal. There are some things that people thought we're doing quite well on, and there's huge regressions in the text. And I think that's not due to civil society input. I think the broader the level of input that people can give, the more varied the perspectives that can be brought to the table, then the better. But then there needs to be a better process as to how to engage with all these different actors and how to make sure that things don't get lost or mysteriously some things are promoted in the final text and other things which probably should have been there, or some initial limitations are then excluded. I think the problem here is with the system, but not so much with the inputs.
I also want to note that we're at time, so I'm going to ask the panelists to answer your questions, if you can, briefly, and then also to end us on a positive note and to tell us one thing, big or small, that we could do either individually or collectively to support more participatory, inclusive, and equitable neurotech governance. So I'll start with Pavel, and we'll go through the panel.
Okay, so maybe to the question about the different national approaches and whether this will put us at the risk of fragmentation. Well, we have a series of regulations that we mentioned during the discussion that apply directly across the jurisdiction of the European Union. But of course, individual countries, and Spain here is a notable example, can go further in their level of protection. I think this is entirely legitimate. I don't think there should be one recipe for all, because the legal systems are different, the cultures are different, and therefore, if Spain thinks that going in the direction of neuro rights could be, in line with its legal tradition and legal culture, I think that's perfectly fine, and that should be, accommodated within the joint approach.
I wanted to very briefly go back to your issue. I think you asked, so what are the issues that are being discussed? And very briefly, very briefly, I think that a point to consider is that sometimes there is not enough conceptual clarity in a number of discussions. So one of the things I think that before we even go to, again, any type of legislation, it is important to really fully understand what is at stake, why it is at stake, what is it, as I said before, that we want to protect and why we want to protect it. And I think that that has to be the basis of the discussion. It is true that sometimes conversations can go the dystopian way, and suddenly it became, and it has happened in some cases. I have to say that, for example, in the Chile case, sometimes the discussion was very much a discussion about robots taking over. So I think that is a danger that needs to be avoided, and that's why I am really very much into keeping really very mindful of what are the notions we're using and why we're using them, and exactly what is it that we want to do and how. Something that we can do collectively or individually. I would say we should avoid, in order to really have positive participation, avoid tokenism. That would be my one
Lovely.
word.
Thank you, Arlene. Daryl?
Yeah, I'll just address some of maybe the hype about the dystopic stuff. I think there's a lot of, maybe Arlene was saying this in another way, I think there's a lot of concerns about agency and people losing free will. And there's clearly governments out there that potentially would take advantage of such a device, and I think those fears are set in reality, but it's probably not the thing that would happen immediately or things that we would be concerned of. I think as maybe we've said on this panel, some of what the concerns are just grown from the concerns we have now in modern life around privacy, around inference being made and judgments being made that we can't control. And this just may be a more sophisticated way to do that. A positive thing, I will say that, once again, we live in a different world. I think we're faced with a population, a significant segment of our population that has and suffers from mental health conditions. I think this technology potentially could be an amazing way of alleviating that suffering, and we have to think about that. And for participation, I would want, I don't know exactly who's in the room, but if you're involved in this research, if you're involved in developing these technologies or thinking about developing these technologies, I would encourage people to look for opportunities to talk with diverse audiences and find partners that are able to do this, and find opportunities where you are taken out of your bubble and meet people that you normally wouldn't meet, and hopefully have discussions about the work you're doing.
Thank you. And Laura, the last word goes to you.
I want to second wholeheartedly what was just said. And from the civil society perspective, especially when it comes to being present, being in the room when new digital policy laws or other efforts are being negotiated or discussed, I think it's really key for those of us who have perhaps digital policy or tech policy experience to make sure that other organizations who will certainly be part of the affected populations are in the room as well, and use whatever leverage we have to make sure that they are present too. And if that's not possible, that we are elevating those experiences and views in our own advocacy. So a concrete example of this was in the AI Act negotiations. There was this coalition that formed, made up of, I think, entirely civil society organizations, many of them in Brussels, which was called the #ProtectNotSurveil coalition. And this coalition was solely devoted to highlighting the harms, the potential harms of the AI Act on people on the move, on migration. And they had some good wins. For instance, migration and border control being included as a high-risk category in the AI Act is all owing to the efforts and the advocacy calls of this coalition. So it can work, but it takes a lot of effort.
Yes, thank you so much. And I must say also, the people on the move, like migrant perspective, was completely absent from the AI Act. So this is actually, we can be very critical of the outcome of the AI Act and disappointed that it wasn't truly human-centered, but there were a lot of wins in that sense. You just have to find them. So thank you all so much. Thank you very much to the panelists for this insightful, very lively and fruitful discussion. This is not the end of the discussion, but only the beginning. We will be doing many more of these types of convenings. So if you want to learn more about neurotech, AI, and all of the ethical and legal potential implications, please feel free to reach out to us. And until next time, thank you.